Hi, this is attorney Stephen Spano.
And I'm attorney Andrea Witt with a legal and financial minute or two. In this episode, we will show you a catastrophic problem we frequently see when children and grandchildren inherit IRA funds, and how to make sure it doesn't happen to those you love.
If you have an IRA, you're likely to have named your spouse first as a beneficiary, then your children, and then your grandchildren. The goal is to be able to take care of yourself, then those you love after you're gone.
Once one of your loved ones inherits an IRA, that account gets transferred into the name of the person who inherits it. Let's say that person is your child, Max. Once the account is in Max's name, Max can withdraw the funds over a period of time, or Max can withdraw all the funds from the account in one lump sum. Withdrawals from IRAs require the financial company holding the IRA to withhold 10% for the federal tax and 5% for the Massachusetts tax.
So what's the problem? The problem is that Max and millions of children just like Max have not saved for retirement and have not been good money managers throughout their lives. This inheritance of this IRA is unlikely to make them save for retirement, nor is it likely to make them good money managers. So what does that mean? Max is likely to withdraw all the funds at once to meet some perceived emergency or need.
Max's withdrawal of all the money just created two problems, one far worse than the other. The first problem is that the inheritance left for Max is now gone, and Max now does not have any money for the retirement or the future.
The second, and the far more severe problem, is that Max had the financial company withhold the minimum tax amount. That's that 10% federal and 5% state. So why is this serious? It's serious because the actual tax due may be far greater than the minimum withheld. And come next April 15th, Max could owe tens of thousands or even hundreds of thousands of dollars in additional taxes because the actual tax owed was far greater than the minimum that Max had the financial company withhold. Max is also likely to owe penalties because the amount that's withheld is supposed to be close to the actual amount of the tax, and since Max did not withhold an amount close to the expected tax, there'll be a penalty. Worse yet, Max doesn't even have the money to pay the taxes or the penalty. Max spent it, which means that the IRS in Massachusetts will likely be taking legal action against Max to get the tax, even if that means garnishing Max's wages or more serious action.
So how can you keep Max from withdrawing all the money at once and keeping the IRS and the Massachusetts Department of Revenue from going after Max for back taxes? The answer is a unique type of trust that can distribute funds to Max on a weekly, monthly, or yearly basis so that the funds will be there for Max for years to come.
The trust can benefit Max by making sure that Max does not withdraw all the funds at once, and by doing so guarantees that Max will have funds for Max's future and avoid those catastrophic IRS and Massachusetts Department of Revenue problems.
Remember, all lawyers and law firms are not created equal. Seek out an expert law firm that is experienced in these type of trusts to help you and your family.
We hope this legal and financial minute or two has helped you and those you love to protect your health, your assets, your income, and your way of life.
If you have any questions on this or any other important legal or financial topic, call or text Spano and DeWicki at 781-231-7800 or email us at help@spanodewicki.com.